Hi, my name is Amish.aggarwala. I'm an advocate practicing in Delhi, and I wanted to talk about whether you should pay money to the police officer who is investigating your case, to the investigating officer, if you have been accused of a crime. It happens quite often when people walk into my office as persons accused of any offense under Indian law. They come and tell me, or they ask me, that the police officer who is investigating their case has assured them that if a certain sum of money will be given, there is an implied understanding that the police officer will wrap up the case, will finish off the case, and they will not need to worry about anything. This happens so often, and I laugh and I cry at the same time every time I see this, because I have to go into an in-depth explanation about how the criminal procedure code of this country works, how all the other statutes of the country works, and how, if long story short, in a nutshell, how it is impossible for a police officer, once an FIR is registered, to help out the accused person in any way. There is a certain amount of leeway that a police officer does have if they do want to, upon taking a bribe, want to decide in the favor of an accused person quite liberally, but often, as a matter of practice, they do not do so, not out of the goodness of their hearts, but for the fear of repercussions, because they understand that at any point of time, if they make a very, very strong case against the accused person, they will never be judged, they will never be accused of accepting any bribery. However, on the other hand, if they create a slightly weak case, or if there is even a perception of there being a weak case, they can definitely be hauled up. Every day we see in the news about how police officers are arrested, police officers are alleged to have taken bribes and not done their investigations properly. And that is why, even though there will be assurances by the police officer, implied or even sometimes explicit, that yes, I will make a favorable case for you, or I will just finish off this case. First and foremost, even if the FIR is not registered, still, if the complainant files an application before the court for directing the police to conduct their investigation, it becomes very, very difficult for the investigating officer, whoever has been marked the file, marked the complaint, to give a finding favorable to the accused person. Sometimes they do it. However, if the court directs them, then they must. So every time there is any situation like this, I have to remind the client, and I'm reminding you, if you have ever been accused of an offense, or for you to remember that if you are ever accused of an offense, there is no point in giving any money to the police officer. Of course, it goes without saying, it is very, very illegal. The Prevention of Corruption Act of India prohibits it. It is morally also very, very wrong. But keeping aside the legality and the morality, I understand that when a person is faced with certain imminent repercussions or consequences, or just a bad situation, they do not really think about the law or morality. They just want to get out of the situation. Even practically, I am explaining to everybody all the time, and I'm explaining to you, the viewer, right now, that giving money to the police officer never helps. There are a couple of reasons why. One is that police officers are often changed. I see from time to time investigating officers being changed, being transferred regularly. There's one matter that I filed a couple of months ago. I filed a complaint. I filed an application for direction to register an FIR in the court immediately thereafter. In that case, within the past 6 months, the investigating officer has been transferred 3 times. It's not that because of some other reason they are transferred from the matter. It's just that they are transferred from one police station to the other. So they have to give up that case. Another thing that happens a lot is, and this is like a practical example that I'm sharing with you, in one of the cases that have come to me very, very recently, there was an allegation, a slightly severe offense. Now, till the time the police officer has that case with him, he still has a little liberty to kind of deal with it in the way he deems it fit. But the moment there is an application in the court, or there is some perhaps media reporting or anything of that sort, the moment that happens, the police officers have no option but to proceed in the case and proceed against the accused person. Apart from that, even though the investigating officer has a certain amount of leeway in recording the testimony, the statements of the witnesses to the incident or the witnesses to the offense under section 161 of the Criminal Procedure Code. As I mentioned earlier, the police are always afraid of the repercussions, and even though they will take money from the accused person, they will in all likelihood create a report which does not favor the accused person. And you will not be able to do anything about it, because if a police officer does ask for money and does get it from you, the police officer will conveniently sit on the case for several years, giving you false assurances that the court cases, that the matter is done with, you never need to go to court again. And when he is transferred out and the next officer comes and he looks up at all the files, then he realizes that this one case nothing has been done in the past several years, and then he starts calling you again, or he goes and submits the charge sheet in the court, and then you realize that the matter was never over. Because once once an FIR has been registered, after that the police will either have to file the charge sheet upon completion of the investigation, or they will file a closure report again upon completion of the investigation, saying that we did not see any offense happening. And even at that point of time, the victim, the complainant, can move in and file a protest petition in the magistrate's court and challenge that closure report. And upon that, the magistrate has the power to either treat that closure report as a charge sheet and still proceed against the accused person, or direct the police to do further investigation. Either of which scenario, if you are accused of an offense, you will not be able to get out of it. And apart from that, there is the other option of approaching the High Court of the state for quashing of that FIR under section 482 of the not section 482 of the Criminal Procedure Code. There is actually a judgment of the Supreme Court of India which says that a section 482 petition cannot be entertained when there is only an FIR and nothing is pending before any court of law. And therefore, when there is only an FIR, the wide power, the proper remedy will be of the wide power of the High Court under Article 226 of the Constitution of India. I learnt this a little the hard way, because I filed a petition like this. I was pointed out by the registry of the court around 2 years ago that this is what needs to be done. Well, it was a good lesson learned that I'm sharing with all of you now as well. And it was etched better in my memory as well. Coming back to the point. The whole summation, the long story short of all of it is, if there is a case against you, majority of the times there will be no purpose in giving bribe to the investigating officer. Of course, I have to reiterate, it is completely illegal, it is very, very immoral, but practically speaking, it is not going to help you out in any way whatsoever anyways. Instead, focus better on your defense, focus on collecting evidence which proves your innocence. And most definitely, if it's a serious non-bailable offense, get anticipatory bail as soon as possible. Maybe I'll talk about all these other things on future videos. For now, this is it. If you like this video, please like it, subscribe to the channel. That's all for this time.